I don't think we know how to do this in an organized way, would we?
That's right. Well, it looks like we're live, right? So
Yeah,
welcome,
I believe we
welcome
are.
everybody. So John, my goodness. So for those of you guys watching us, this is Legal Ease with John Watts Esquire and Stephen Palmieri, and we attempt to come to you twice a month on Thursdays. But my goodness, John, it seems as though we haven't even done a show all year. And now I know that that's not true, but that means we've been letting our audience down because I think we've missed a couple episodes. So, but
Yeah, we've missed a few, and so we decided to get the gang back together this time, and although I was thinking about the next one would be Thanksgiving, which probably your 7 month old will have you occupied on Thanksgiving, so we probably need to skip that one.
we're actually going to do. They've got this little. It's like a 3K or a 5K called the Turkey Trot. I don't know if that's just a common name. I'm sure it's a common name because there's like three of them here, like in the metro area. Like pick which location you want to go. We're going to do the little Turkey Trot. See how that works out with an 8 month old. But there you go. Do a 5K with a baby. Maybe we'll
All
just
right.
strap her on. But for those of you guys watching us live, welcome. Glad to have you here. And comment, chat, throw in your comments below. We do this for you. Anything and everything credit related. If you're a consumer, that's amazing. We love you. If you're a credit repair company, we love you. If you're an attorney, we love you. And if you're none of those three, how did you get here? But we love you as well. So, John, what's going on in your world, man?
We're still fighting. It's been some pretty good battles and just jousting with the credit bureaus and some debt collectors, and so that's keeping us busy. And I know
Yeah.
you've been busy with your software, and I want to get to that in just a second. But just I see Sean's on here. It's good to see you, Sean. Um, you guys just put any questions you have. Sometimes Steve and I say we're going to go like 45 minutes, and then it's like 2 hours and 45 minutes. And this time, though, although Steve doubts me, I do have a deadline. I've got to get off at 5 o'clock Central. So if you put your questions in, even though I talk very slow, maybe I'll have Steve answer everything and he can speed up the
Well,
volume a little
I
bit.
I do doubt that you'll be able to get off in precisely 1 hour. I don't think it's in your blood, but it's also true that we go 2 hours and 45 minutes. And you may not believe this, John, but typically I have to suit up with a catheter because like when we're here, it's like, dude, I mean, it's game time. I may not be able to get up for hours and hours, and you just can't get up and take a break. So it's going to
Yeah,
be nice to
that's
just be able to get
impressive
out.
and disturbing all at the same time. There was I'm trying to think of his name, but there's a lieutenant governor in Alabama, and it's sort of like the filibuster, as I recall. Like he had to keep speaking to like stall a bill, and so he had somebody bring him like a big jar. Yeah, so behind the podium he could relieve himself. So that's dedication or disturbing, one
Yeah,
or
that
maybe
really
both.
is because in Congress, if they do the filibuster, right, they literally can't leave. So I mean, they either have to have one freaking hell of an Olympic bladder, or they got to have that sneaky leaker tapped into them right there. So, but all right. Well, you said you've been handling up on the bad guys. What does that look like these days, John?
A lot of what we're doing is with the FCRA, which that's not really a change, but there are a number of issues with Fair Credit Reporting Act that are kind of leading to more litigation and more battles. And one of those is the idea, and you and I have talked about it on the show before, Stephen, and that is uh, you have to dispute an error. Okay, well, what's an error? Well, there are a lot of courts that say that is not, at least for credit bureaus, not a legal issue. In other words, you can't say, hey, I think this loan is void because it violates some Alabama or Georgia or Florida law, and then require the credit bureaus to sort of be the judge. And so they've had some success with that, but what we also see them doing is when a judge has decided the issue. So we'll get to it in just a second, but I see somebody said they've been sued by Synchrony Bank. And so let's imagine you're sued by Synchrony Bank and you win that case. And then you go to the credit bureaus and say, hey, Synchrony sued me. I won. Get this off my credit report. The bureaus are saying, well, wait a minute. We can't possibly figure that out. That's a legal issue. And we're like, somebody in black robes decided that. You don't have to decide it. You just have to interpret it. And same thing with like a bankruptcy discharge order that wipes out your debt. The credit bureaus like to say, well, we can't possibly figure out what this bankruptcy discharge order means. And the courts pretty uniformly say, yeah, I think you can do that. And so that's an issue that is sort of ratcheting up in intensity in my world anyway. And hey, we'll get to these questions here in just a second, but Stephen, why don't you tell, especially for the credit repair folks that are watching, do you have any updates on your software?
Well, we do. So, as I think you guys know, we came out about 2 years ago with Palmieri system to beta. It was beta, got us launched. First software to let you do dispute letters with the data merged from all three bureaus in one letter. So if you're auditing the data against their industry standard, you can actually kind of nicely make nice mail merge templates. And we're in a complete rebuild phase here. We'll be able to pull an annual credit report too, which is going to be really exciting for the pre-lit folks. And that's why we're doing it. We're not doing it to compete with anybody else. We're doing it to create an amazing product where if you want to build case files, you'll be able to do that. So yeah, John, I've got a whole army. We're doing a complete rebuild. We'll have a nice API. You'll be able to connect it into your CRMs and stuff like that. So yeah, to be, how should we say, to be continued, as we say, John. So, but yeah, we're making some pretty good progress on that. So,
well, very good. Well, we'll get serious here in just a second, but my
friend, no, we're not going to get serious here in just a second, John.
In just a moment. So this is, I was mentioning, we had a guy in Alabama that used a jug or a jar, and so he wouldn't have to leave the chamber. So Jared said Pixar didn't have him. So this is not exactly a picture, thankfully, but let me see where this is here.
Are you Googling right now? Are you going to pull us up something from like, one of these websites that's probably barely suitable for adults?
Yeah, this may affect our ratings. No, this is Wikipedia here. So if you can see here,
our ratings can only go up from here, John.
Yeah, gained notoriety in 1999 for discreetly urinating into a jug behind his desk while presiding over the Senate, this Alabama Senate, purportedly to avoid being stripped of his powers as presiding officer by a Democratic majority while going to the bathroom. So, if you ever think you're having a rough day, just think of that guy. All right. So
there we go. So Jared, we don't have pictures, but we have it on Wikipedia. And as you know, Jared, Wikipedia, if you are in an English class, Wikipedia is an absolutely valid, credible encyclopedia, right? And so if it's on Wikipedia, it's got to be sourced and truthful, right? There's no bias or fake news going on in Wikipedia. So
that's right. So here we have, let's see, being sued by Synchrony Bank, and I don't really see a question here, but I've just point out to you, whenever you're sued by a debt collector or an original creditor, you've got to make sure that you respond to that lawsuit. Whether you do it on your own, you get a lawyer, but please do not ignore that. And I would definitely get with the lawyer in your state, even if you don't hire that lawyer, just to find out what your options are.
Well, now, John, don't be trigger happy on that slide yet real quick there, because I want to chime in and get your input. So as you know, like arbitration is kind of really a big thing that everybody's talking about in the credit repair world. And we've got an amazing course hosted by Shiva, who's an attorney. You can go to arbitrationtrainingcourse.com to learn more. But the point there is that if she's being sued by Synchrony Bank, there's a pretty decent probability they may have an arbitration clause in the original contract. Okay, so I don't know if that one does or doesn't, but a lot of your credit cards do.
Synchrony almost always does.
So can you throw out a little factoid? Because I mean, what I've been learning through learning this whole arbitration thing is that if you get sued and there's an arbitration clause, you should, as the consumer or the defendant, be able to file some motion with the judge and say, hey, judge, I mean, they can't lawfully sue me because they're violating their contract. This thing needs to get thrown to arbitration or something. Now, that's not the legal way of putting it, but that's just kind of the street way. Can you chime in on that? Because maybe that could help her out with this suit potentially.
Yeah, so almost all credit card agreements have arbitration. Now, they're like Capital One typically doesn't, but Synchrony, Community Bank, Most of the ones that end up suing do. And those arbitration agreements, again, almost always have an exception for whatever the small claims version of your court is in your state. And but as a defendant, you can ask the court to what's called compel arbitration, to say, hey, make them arbitrate. Now, sometimes because of the cost of arbitration, the original creditor may say, well, we're not interested in doing that. But I will say this, just as sort of a cautionary warning, which that might be redundant when I think about it, a cautionary warning, but a cautionary statement, we'll just say. Sometimes people think arbitration is like the silver bullet, the get out of jail free card. And so they do this, and maybe they're sued for $5,000, and it's going to cost the company $3,000 to arbitrate. And they say, well, there's no way they'll do that. We've seen them arbitrate when the arbitration cost is more than the amount sued for. Well, why would a credit card company do that? It's to send a message to say, we'll lose money on this so that people don't think they can just wave arbitration around and, that makes everything go away.
John, I hate to be that guy, but I'm always
still after like 3 months of being off, you're still that guy.
I'm still that guy. Yeah, they want to spend more money on arbitration and litigation to send that message. Aha, that's what you think. You're going to read our contract, and we forced you to arbitration on our contract. Well, we've got a thing coming. We're gonna act as if we're litigating. We're going to outlawyer you through mediation. Because the irony in that, John, is that that's a provision of their contract, right? Like when they create the contract, it's completely one-sided. They're like, sign it or leave it. They put in there. Well, let's talk about that a little bit, right? Because they put arbitration in there typically which a lot of them say, you hereby waive your right to class action, right? I mean, that's kind of the
whole point. Yeah.
That's the big beauty of it, is like, we're gonna have you agree that your ass can't class act us. And oh, by the way, even if you want to single act us, you can't do that either, because you're gonna have to arbitrate us. And so what you're saying, they're gonna act as if they're litigating. They'll spend $100,000 on an attorney or whatever to go to arbitration. But I mean, there's still a certain level of reasonableness, because you're in front of an arbitrator, and it's the American Arbitration Association. So let's talk about how can they really outmuscle you in arbitration, because it's not like the game of law where it's like really a game. It's like motion this and motion that, and oh, your evidence is inadmissible because whatever, and next thing you know, it's got nothing to do with anything reality. It's got all to do with the game, right? And how much money you can throw at lawyers to lawyer you. But at least with arbitration, it is, there's a set of rules. There's either the American Arbitration Association or there's JAMS. So let's talk, how can they really give you death by 1,000 paper cuts with all their money in arbitration?
Well, so the deal with arbitration is typically it's more streamlined. So we're not going to have what in courts called a motion for summary judgment, where they just ask the judge to summarily enter judgment because the judge doesn't think you can win. Here you'll get to your hearing, okay? Almost all the time you'll get to your trial, or what's called an arbitration hearing. But so this can cut both ways. Really, the rules of evidence are very, very lax in most arbitrations, because the arbitrator is sort of the judge and the jury. And so, they kind of say, well, hey, let's bring in all the evidence, and then I'll decide what's valid, what's not valid. So, there are times when it's to your great advantage to be in court and have the rules of evidence, because this creditor or this debt buyer like Midland, LVMV portfolio, they may not be able to prove their case under the rules of evidence. In arbitration, there's lots of things that can come in. And so, they may be able to easily show that you owe the debt. Let's assume that I took out a Synchrony card, $5,000, I didn't pay it back. Well, they're going to be able to show the arbitrator that. Now, the arbitrator might give them $5,000, might give them less. Same thing with the judge. So what I would just, again, caution people is arbitration is not this magical thing that just, has no downside. Because I see people do that, and maybe they have success once or twice or 3 times, and they're like, oh, this is the greatest thing ever. And then they get burned, the 4th and 5th time, because they're assuming people will just roll over, and not all creditors will.
Now,
And
John, you're just saying that because you're a consumer defense, not arbitrator, but attorney. And you don't want these people to make you obsolete and out of business. You want them to come to you to litigate. Isn't that right? You've got a really
we do a ton
self-proclaimed
of
thing.
arbitration, man.
What's that?
We do a lot of arbitration. So
Yeah. How do you
so
decide, like, which
it's a
way you
funny
go with it?
thing. Yeah, it's a funny thing, Steve. About 20 years ago, arbitration really started coming into popularity among the defense side. So when you sue companies, and then the idea of getting rid of class actions. And it used to be that a defendant would force you into arbitration, and the plaintiff's lawyer, the consumer lawyer, would just sort of give up. Well, nothing we can do. Well, now that has kind of shifted to a lot of plaintiffs' lawyers, consumer lawyers are embracing arbitration. And now we see just this like weeping and gnashing of teeth by the defense lawyers. I'm talking about corporate defense lawyers, because, let me give you an example. Maybe they rip off, 100,000 people $100. Well, kind of hard to sue, if you can't do that as a class. So now people are doing what are called mass arbitration. So you get 200, 500, 5,000 clients. You say, okay, no class action. We'll file 5,000 arbitrations against you. And so, about the minimum costs in AAA is about $3,000 to get through a day of hearing. Jams could be, we've had jams cases where they say to the other side, okay, stroke us a check for 15 or 20 grand so we can get started. I mean, very, very expensive. And so the companies are freaking out, going, wait a minute, this is unfair. This will cost us too much. We need like one case to represent them all. And the judges are like, you mean like a class action that you banned, And so it's really funny. The roles are shifting where plaintiffs now are embracing arbitration, and companies are going, whoa. Maybe we don't like arbitration. We thought it was the silver bullet. And now they're finding out that it's very dangerous for them. So
Yeah.
we just have to look at it. Where would your court be? Which are you in AAA? Are you in jams? Do you have maybe the law is more on your side? Maybe the facts are more on your side, and you make judgment calls about where's the best place to go. And in the debt collection world, like you're sued by a debt collector or original creditor, you really have to know your local judges. Because you may say, hey, this judge is better than any arbitrator, or no, this judge, always rules with the collector or the original creditor. So you just have to know kind of where you are there.
So to kind of tie it back, so as we started, we got a YouTube super fan poster, and this person is being sued by Synchrony Bank. So if this person is not able to afford or find or get a lawyer, do you think it would be smart? Obviously, your disclaimer, you're not giving legal advice and all that kind of good stuff, John. So because you're a lawyer, you gotta lawyerly tell them you're not lawyerly telling them. I get how that works, but let's just say you're George Clooney. You're not a real doctor, but you just play one on TV. Let's say you're playing a lawyer right now, okay, for this guy or gal. Would you recommend this person tries to file that motion if this person's not able to get a lawyer? Or first, I guess, so first I would say go to the CFPB website, okay? And then you can pull a list of credit card agreements from the CFPB website, okay? Literally, they have a database of every credit card agreement, okay? Little factoid right there. So if you can find that your Synchrony agreement, if this person is able to confirm that the Synchrony agreement has an arbitration provision, there you go right there. And this person is not able to retain counsel, do you think it would be a smart move to file that motion with the judge to try to compel arbitration?
Yeah, I think that can be a good move. You still need to, in my view, respond to the lawsuit. Okay. But you can respond and say, hey, this is governed by arbitration and I want you to arbitrate it. Now, one issue is most judges will say, well, okay, Stephen, you have to prove that. And so you need to have the arbitration agreement inside of the credit card agreement. So this is like Synchrony Financial. And I mean, this database has just tons of, all these companies that you can see. And I'll drop the link in to the comments here. And so hopefully that'll be helpful. But You look at that and you say, well, this looks like my credit card agreement. Sometimes the lawsuits will contain the credit card agreement. That's helpful. If the plaintiff, Synchrony Bank or whoever says, here's a credit card agreement that we're suing you on, you go, great. Look at page 3.
Nothing like them suing you and including as Exhibit A the agreement that says they can't sue you. John, nothing says we have the best of the worst legal systems in the world like that.
Yeah,
right?
well, keep in mind that the agreements don't say they can't sue you. It just says that whoever sued can move to arbitration, but sometimes they completely carve out small claims court. So again, you have to read it and not just, here's what I see some people do. They go, I'm just going to call the collection lawyer and go arbitration. They're going to like fall over and, fright. That doesn't work that way. So you got to be smart about it. You got to do your homework and make sure that you are doing this correctly. So let's grab a couple of these here. So I had a charge off disputing about 2 years. Company never sold to a collection agency. All of a sudden just started giving me late payments for the last 12 months. Is that legal? So if I'm understanding this, Steve, we've got a charged off account, which you should be getting a charge off every month in terms of the payment history. And then it apparently switched to some late payments. So what would you say about that?
That sounds like a hot, sticky mess. I would love to see that credit report. If you want to maybe chat it to John or me, Facebook Messenger, you can get us there. But so if it has a balance, it can be charged off with a balance, and every month they can still update it because it has a balance. So you still owe on it, and like that payment history would show CO or charge off, something like that. Now, if it's a paid charge off, that's what's considered a final status under Metro 2, which Metro 2 is their industry standard format for reporting data. So once an account has achieved final status, it can't be like more final than final. So then there's really no room for them to continue to update it. It's like a paid charge off. Obviously, it's a closed account and it's paid and it's closed and it's charged off. So that's a final status. So in your case, if you've been disputing it and it was a charge off and there was a balance, but now they're showing late payments. Well, typically they shouldn't continue to show late payments. They should show that it's charged off. And this is kind of one of those esoteric philosophical conversations, John, because if they're going to suggest to you that you're 120 days late, then that would also suggest it's not charged off, which means that it's not been accelerated, which means that if you were to pay the 4 payments that are causing it to be 120 days late, it would get caught up and be a positive account, right? So that's why we really want to look at the trade line and see how it's reporting. But that's probably not actually reality. But that's kind of reality of how this would paint a picture, right? Because if they're saying, oh, you're just 30 or 60 or 90, oh, well, good. That means let me get caught up and this becomes a positive account, right? Once it's charged off, there ain't no 120 or 90 or 60, John, once it's charged off, because the charge off basically means they've written off and you owe everything. So, yeah, if you want to send us that credit report, we could take a look at it. Would definitely love to kind of dive in and see what's going on with that. Really cool scenario.
Yeah, and make sure that you're pulling that from the bureaus themselves, preferably annualcreditreport.com, and just make sure that you have, Steve, I was about to say accurate data. Accurate reporting,
John,
bureaus are saying.
John, I've been subpoenaed by the credit bureaus multiple times, as you know, by having had clients sue them, and then I become a fact witness, and they're like, oh, we're going to go ahead and subpoena Stephen. And I've said to these credit bureau lawyers on numerous occasions, I've never seen an accurate credit report. And would you believe their attorneys have the gall to look over the deposition table and say, John, do you mean to tell us, Mr. Palmieri, that you have never seen an accurate credit report ever? And to which I respond, no, that's not what I mean to tell you. That's actually what I just did tell you. All right, John, let's continue on here. Let's move forward.
All right. Yeah, let's see what we got here. Oh, and just this will close the loop here. When Jared said pictures or it didn't happen, he wasn't talking about the guy in the house. So fortunately, there's no Wikipedia Stephen there. So sorry about that.
For those of you guys joining us recently, forget about the catheter comment that was that
Yeah,
had
you
no
got to go
bearing.
back and watch like the original footage here. All
That's
right,
right. You
let's
got to
see
watch the
here.
replay. That's what you guys get for joining us late, is you miss all the good.
All right, so let's try to be productive here. Crystal says, I've disputed a collection about 3 rounds with the Bureau's factual facts, nothing resolved. Submit a claim, Better Business Bureau, nothing. CFPB, Attorney General in Florida, and still waiting. And let's see, I think this may be the rest of it here. Can a collection validate an account with only statements, bill of sale? So this is Absolute Resolutions, a debt buyer. They say it's not necessarily a signed agreement to validate it's furniture. Is that right? Then let's see. Disputed a charge off to discover factual facts. Just got TransUnion deleted. Okay, so kind of a lot there. Let's um, let's
Like
start with
squirrel.
this.
Like my which way is it running? Definitely a lot there, Crystal, but that's really good stuff. So we've got factual credit reporting disputing you mentioned. We've got validation, which are kind of two separate things. So John, go ahead, start to dissect this one bite at a time.
Yeah, so this debt buyer, and I assume, Chris, you're talking about Absolute Resolutions. They say they don't have to have a signed agreement, and it looks like talking about the original agreement. And I can tell you that that's certainly true in Alabama. There's not always a signed agreement. Some of these things are done electronically, some are done over the phone. It's a little unusual to not have a signed agreement. Okay, but what I'm saying is there is a context where that might be okay. Uh, but this will go to what we were talking about a few minutes ago, this sort of legal factual deal, which I don't believe is correct under the Fair Credit Reporting Act, but there are judges that do. And so if you're saying to the credit bureaus, hey, you have to get rid of absolute resolution because they haven't showed me the original signed agreement, then that's just not something that the credit bureaus typically are going to resolve in your favor because they're going to say, well, we don't know, you know. So I would look to see, is there something else that you can kind of hang your hat on? Is there something about the reporting? Is there any missing data? Are you getting any letters from Absolute Resolution? So think in terms of the FDCPA, Fair Debt Collection Practices Act. Can you do something or find some error that Absolute is using in their collection, but also the Fair Credit Reporting Act, the FCRA, and that's going to be through the bureaus. So, what I would suggest is since you sent that to Florida, I'm assuming you're in Florida, I would get with a consumer lawyer in Florida and say, hey, can you look over this? Do you see anything? You know, look at my disputes. Let's see what I've done. Have I done everything I need to? Is there something else I can do? And then just to follow up on that with Discover, it sounds like you got TransUnion deleted, still disputing with the other two bureaus. You certainly can tell the other two bureaus, hey, I got this deleted from TransUnion. It might help. But from my vantage point, you need to find the errors on Equifax and the errors on Experian and send those letters. And again, get with the lawyer in Florida about that to see how they violated the law. It sounds like you've done a number of disputes. And if they're violating the law, you sue them.
Yeah, and kudos with the factual disputing, right? I mean, like looking at it and finding this wrong. That's good stuff. And if you need help finding a Florida lawyer, reach out to John or myself. We've got some referrals.
Yeah. So let's see here. Oh, that's all right. Karamu, I'm in Alabama. Hey, good to see a fellow Alabamian. Asked the collection attorney if he had an agreement stating they own the debt. He said they don't need that anymore. Have to go back in January, and I think that's it there. So let's sort of be precise what we're talking about here. The collection lawyer certainly doesn't have to have some agreement that they show you that the collection lawyer owns the debt, or even that the collection lawyer has been hired to represent the debt collector. Now, I think in trial, they do have to show the debt buyer that's suing you has to show that it owns the debt. And so then we're talking about the purchase agreement So you've got original creditor, say Synchrony Bank, and here you have portfolio recovery. Well, Synchrony Bank, to get it to portfolio, they've got to sell the debt. There's a contract. So it may be called a forward flow agreement, credit card purchase agreement, just a purchase agreement. And they do not like to show those. They have them, but they don't like to show them because a lot of times they say, oh, by the way, we don't make any promises, or the fancy word is representations, about the quality of or the accuracy of the documents. Well, the debt buyer definitely wants to show that, hey, these are all accurate documents, the statements and all the information they have. So they tend to not like those purchase agreements to come in. But if you want to get with me, you can send me a message through here or just through my website, and I'll be glad to look at your situation and what judge you have and give you some thoughts on that.
So quick thought there, John. So I believe she had said that on her first post that was it the lawyer representing the debt collector said we don't need that. But now under the FDCPA, it's unlawful for them to collect on a debt that they either don't have the lawful authority to or otherwise under the contract authority to, right? So,
right.
I mean, is there a way for her to weave this into a potential FDCPA argument, like saying, well, I'm just simply asking, I mean, how can you collect on something if you can't even show me you have the legal authority to collect on it? Does that tie together, or is that too far out there?
It's probably a little far out there when there's litigation going on, because that's sort of the whole point of the lawsuit is, can the debt collector show it owns the debt? Now, if it can't show it owns the debt, it does have some interesting implications. If it never owned the debt, then did it violate the law when it filed the suit? I mean, we filed, I don't know, 100 of those cases, when they can't show that they own the debt. But again, I like to have it where a judge has ruled in my favor before I do that, so that it's very clear and it's not me saying, well, you can't prove it, and they're saying, well, yeah, we can, we just don't have to show it to you. And so we like to win the case and then go after the debt collector.
John, I just want to point out for you and for your listening and viewing audience that when you said that if they can't prove it, it has some interesting implications, you looked like a Rottweiler with a T-bone steak at that point in time. The interesting implications means you're going to latch onto that bad boy and not let go, right?
Something like that. So let's see. This is a big national firm, Rouse-Sturm. They're, I don't know, probably 35 states collection lawyers. When they sue for Synchrony Bank, but there's no court file on the summons, heard it's called a pocket summons. I'll be honest, I'm not familiar with that terminology. That's not how we do it in Alabama, or for my co-counsel, Blaine Dixon in Tennessee. So if you filed an answer, that's certainly good. And I would just, I was looking to see if we had any follow-up there. I don't see it. But, I just asked the court, hey, is there a court file? I mean, it seems a little odd. It could be that it's sort of filed, and before the court gives them a case number, maybe the lawsuit went out. I don't know. It could be just, a mistake, or that may be the way that particular court does it. Here's kind of a detailed one from Sean. So why don't you take this one, Steve? For my FICO credit monitoring under worst delinquency, and we'll ask you, Steve, if that's a field in Metro 2, has 120.
No.
Yeah. So either 120 or 108 days. However, under the 2-year payment history, it's not listed. What's a good angle to dispute? Why don't you take that on? I'll see if we have any follow-up from Sean there.
Yeah, I mean, the worst delinquency, they're trying to say when was it most delinquent, essentially. What I would recommend is get your annual credit report. If there's nothing that really stands out to you from the FICO report and you're trying to figure out which way to go, get your annual credit report, because those are the data directly from the bureaus. My FICO is, they're like an intermediary, and so it's not even really the real data. It's kind of odd to say that, like they literally get it and jack it around, but they do, and then they add things to it.
When you say that, say it's not the real data.
The real data. That's right. That's right. So think of like Austin Powers,
That's
so
right.
what I would recommend, Sean, is get your annual credit report. or write or mail to the bureaus to have them mail you your direct report. And forget about what that worst delinquency thing says. Just actually look and see everything that's wrong with those reports, and I would use that as the subject of your disputes.
Yeah, and I'll say this, Sean. I personally have a subscription to my FICO, and I think it's great to know your FICO scores. Because there's not just one FICO score, right? There's a ton of FICO scores. Uh, but as good as it is, it's not the real data. It's not the same as looking at your actual Equifax, Experian, TransUnion. So use it for the value that you can get out of it. But if you want to do sort of precise, detailed work on your credit report, you really have to, in my judgment, use the bureau reports. And I'll say this: I think what you get through annual credit report is more detailed than you get if you just go straight to like Experian and get your report, or TransUnion. At least some of the paid versions actually give you less data. We want more data, because the more data there is, the more we can see the holes in it, the inaccuracies, and we can challenge that. You don't want something that has like this much data when you can get something that has that much data. So data is our friend. Let's get it. Let's look for the inconsistencies, the inaccuracies, the incompleteness, and then we can go forward there with our disputes. Let's see here. We've got, not sure who that is, but somebody's saying howdy to us. So that's nice of you.
Howdy back.
And oh, wow. Steve, I thought we set our security settings for this guy. Did we not do that?
Yeah, Robert's kind of a cyber guy. He must have gotten through our security.
He like hacked through our defenses. So why are we picking on creditors and credit bureaus? We're just like mean people, I guess, Robert. And so, hey, it's good to see you, Robert. So let's see here. Deb says, I have a question about when you purchase a car. Let's see. Best remedy is the UCC book trumps all that you guys are saying. UCC. So, okay. So why don't you talk about that, Steve? Because what Deb is saying here is that using the UCC is better than what we're talking about. And so maybe let's first talk about what is the UCC, and then how do we use it. And I'll say this for Deb and those who are watching. All these things are tools, and it's not that a hammer is better than a saw is better than a screwdriver. It's, if you're trying to hammer in a nail, you don't want a saw. If you're trying to cut something, you don't want a screwdriver. So the UCC is a tool. The FCRA is a tool. The FDCPA is a tool. There are all sorts of tools out there. So let's talk about what is this UCC, and then how do we use that when we're talking about maybe a car loan, for example.
Right. So the UCC is basically like the Uniform Commercial Code, which in itself is actually not a law, right? You had a bunch of folks get together for the commercial contract type industry, the commerce industry, and they drafted a uniform code that they then had all the states basically turn into state law. And so the UCC is what it's called, but you really have to look at your state law to see where it actually is. And what it does, though, it basically governs mostly secured type, other things as well, but it's secured type transactions. Now, on a high level, what I would say is that, well, you're not going to trump FCRA or FDCPA with UCC because they kind of govern their own parts of the puzzle. So like FCRA regulates, well, if it's got to do with credit reporting, FCRA is going to be your guideline. If it has to do with debt collection is your guideline. Now, if you want to go behind the scenes and look at security interests, or maybe things that had to do with the contract that may be regulated by the UCC, that's where that part of the UCC would come in. So to John's point, they're all different tools in your toolbox. Now, John, you had mentioned something like an automobile. So automobiles are secured transactions, and so the UCC covers them. And there's a couple ways under the UCC where you can use the UCC in your credit repair journey. Like there's one part of it that requires that they respond to a request. Basically, if you send them a request to kind of prove up the collateral, if you would, a statement of collateral, they're supposed to respond within 14 days. So that's one way if you have like an auto loan or repo or something. Maybe they're not responding to your furniture FCRA disputes. You can send a UCC letter and ask for specifications regarding to the collateral, which would be the car. And then, when it comes to repossessions, the UCC definitely does govern that. And, the repo must be in a commercially reasonable manner, which is all subject to interpretation. But there's notices that are supposed to be provided to the consumer or the debtor. In this case, is kind of the debtor under the UCC. So, kind of like the pathway to repossession, if you put it like that, is governed by the UCC. And so, I mean, if you've got an auto loan, a repo, yeah, you can definitely tie the UCC in there. But I mean, if you just have like a charged off medical bill or a credit card, UCC doesn't really cover that necessarily. So John, that's my initial pass at attempting to do what you asked me to do, which is answer and reply to our amazing audience here. How did I do, sir?
Yeah, I think that's good. And I'll give you an example, sort of real life example. So I had somebody that had a car, it was repossessed, and it was sold at the auction. And so there was a deficiency. So we owed this much, sold for this much. So the difference is the deficiency. So that was then sold to a debt buyer who sued my client. So we tried that case one day, and they flew in some witnesses and all that stuff. And what it really came down to is the question is, did they send a notice before the repo or before the sale saying, hey, we have your car, here's what you can do to get it back? And then did they send a notice after the repo sale to say, here's your deficiency? And we were able to prove they did not do that. Well, then the question comes up, well, what's the effect of that? And here's where, again, I'm always kind of harping on people, like you got to be really precise with what you're doing and not just say, oh, well, I heard somewhere that means the debt goes away. Well, in some states it does. There's no deficiency. In other states it doesn't. And so there's an argument for, I don't know, maybe a third of the states that you have to show how this harmed you, that you didn't get that second letter, that it would have made a difference. And so what Steve says, very important. You have this, quote, uniform commercial code. And to my knowledge, every state has it. I don't know, maybe not Louisiana, but we don't really, they're like
Come on. I was born in Louisiana.
Napoleonic code or something. I don't know.
This Napoleonic code doesn't mean that there's not a code, okay, buddy? So you watch yourself.
So it's a uniform Napoleonic code. But the laws for the exact same UCC section can be different in Georgia versus Tennessee versus Alabama versus North Dakota. And so you really have to look at your state on that and make sure see what's going on. So here's somebody saying, I'm a hard guy.
That was Warren Maxwell right there. But I am a little curious. I know you're chomping at the bit to get on to that. But how do you prove a negative? How did you prove that they did not send those notices? I was curious about that.
Yeah. So this was a debt buyer, and they had their corporate representative, testify, and they said, well, the original creditor sent the notices. My question is, did you see the person put a stamp on there? Did you see somebody lick the envelope? Did you see what address they wrote on the front of the envelope? And the witness like, well, no, but we know they did it. I'm like, you don't know they did it. You're just making that up. You're just speculating that what they did. It wasn't sent certified mail. That'd be one thing if they had a green card, and the consumer signed for it. But they said, well, here it shows that it was sent. Maybe it was sent. Maybe it wasn't. You got to prove that. That's evidence. And so
their inability to prove to the court's satisfaction equates to you proved it wasn't sent. Is that basically what you're saying?
Right. And this kind of ties back with that arbitration. See, we can't just say, well, there's arbitration, so judge, make them compel arbitration. Well, maybe that's true, but we're the defendant. We're asking the court to do something. We have to prove it. Well, here, this debt buyer sued my client, and they were saying the notices were sent, but they couldn't prove it. And so you have to understand, the fancy term is the burden of proof. Who bears the burden to prove this fact? Well, I didn't have to prove we didn't get it. I had to prove that they had no evidence that they had actually sent it. So that kind of flips it to them, where now they have to actually prove that they sent it. And they weren't sitting there staring at the person like licking the envelope, right, and writing out the stuff. So
Prove it or remove it, buddy. Prove it or remove it,
right,
right?
that's like Johnny Cochran or something. So, hey, Warren, I apologize. I have been sort of buried underground here, but I'm coming up for air a little bit. So if you'll reach out to me, that'd be great.
Warren,
Just
that's not what he said in the pre-show. He specifically said, "Man, that guy Warren, I am trying to ignore him and avoid him."
If I was going to ignore him, I wouldn't put that up. I put them all up, man. All right. Do you have a training program for Metro 2 I can sign up for? Yes, I do. It's a much better version than this sort of fake version Palmieri has. No, I'm kidding. Steve has that. So, Steve, I'll give you 30 seconds for your pitch here.
CreditRepairTrainingCourse.com. Would love to have you in there. 30-day free trial, $99 a month. We have a nice Facebook group. We have all sorts of modules of content built in, and John is in there. In fact, that's how John and I met and connected. And every Tuesday, we have a live Zoom that's usually about 2 hours long, where we go over all the questions that everybody in the group has. So, yeah, would love to have you come in, check out the free trial, CreditRepairTrainingCourse.com. And if you have any questions, Facebook message me. Happy to chat with you.
And I'll say this: there's, I don't know, what do you call them in the Facebook group? They're like modules or units or something.
Well, Facebook, yeah, it's like the guides
thing, I'm in there. So there's tons of material in there.
Yeah. Come check it out. You've got nothing to lose and everything to gain, as they say.
There you go. So,
all right.
Yeah, purchase agreements. I mean, it's just critical when you're dealing with the debt buyer. And this is not anything new. So, Stephen, I don't even know if you were like driving at this point, but like in 2007, I think, I wrote a blog post that sort of, in my world, sort of went viral. It was about you can make a debt buyer prove that they own the debt as well as proving that you owe the debt. That's their requirement. And so this is not something that's brand new. I mean, we've been arguing this for many, many, many years in Alabama and other places. And so there's just a reluctance, not by all debt buyers, but by many debt buyers, to actually put that purchase agreement in front of a judge. And so I've had them in trial where they say, it's kind of like this. They go, we have the purchase agreement over here, and Judge, how about we show it to you, but we don't let John see it. And the judge will look at me sort of awkwardly, and I'm like, that's not how it works.
That sounds like those
show evidence to a judge, and the judge is just up there like, what do I do with this lawyer that asked me that?
That sounds like those. That sounds like those FISA warrants that Clinton got against Trump back then. It's like everybody on that side could see it except for the other people, right? It's like, can't show it to you right now. But John, we digress. But in all seriousness, though, so I was driving in 2007, but I don't think that's really a fair judgment of the scope of time.
How old were you in 2007?
Really, the question is, did you have dark hair back then, or were you gray?
I did. I looked like you back then. So look, in 15 years, this is you, buddy. 15 years.
There you go. Charming, charismatic, and we're going to call you Silver Fox.
And when your kid gets older too, that'll
answer your question. I was 27 in 2007, unless it was the first 2.5 months, in which case I would have been 26. So
legitimately, I thought you were in your like early 30s.
Me? Well, I mean, it's the good genetics. I take care of myself, John, and I humor myself a lot. That's why I do this show with you. It keeps me young at heart. So. And
maybe that catheter too, right?
That's right. Again, for those of you guys joining us now, don't even.
Yeah, it got weird early on, so we're trying to overcome it. So, well, hey, Steve, I've got a few more minutes here, and then I need to jump on a phone call.
Well, let's make it count then. Let's make it count.
Let's see. Tony filed summary judgment against a debt collector. Judge continued my motion for summary judgment. Why is that? Okay, so that's an interesting thing. Let's kind of break that down. A summary judgment is where one side, and in this case, Tony, files a motion, a request to say to the judge, look at all the facts in the case, give every benefit of the doubt to the other side, take those facts and apply the law. There's no way a jury or a judge could rule against me. So let's not waste time having a trial, just summarily enter judgment. And so Tony says the judge continued the motion. So why is that? It could be the other side asked for a continuance. It could be the judge had a conflict that day. It could be the other side said, hey, we need time to conduct discovery, take depositions, gather more facts, more information. And let's see here. At all the facts, there was a genuine issue of material fact. Okay. So a continuance just means it's being postponed. There's not a ruling on it. What Tony's talking about here is kind of the standard definition of summary judgment is there's no genuine issue of material fact, and the person moving for summary judgment is entitled to judgment as a matter of law. So let's use a simple example. We use a car wreck. Steve and I have a crash together, and I sue Steven, and Steven files summary judgment and says, I had the green light, that Steven had the green light. And if I admit that, then there's no argument about who had the green light. And so Steven probably wins that. But if Steven says that he had the green light and I say, no, judge, I had the green light, the judge goes, well, I can't decide. That there's a genuine issue of material fact here. We need a jury to decide. Now, sometimes judges try cases without juries and they still say, well, this is a question of fact that we have to decide in a full-blown trial. So you're trying to show, if you're the consumer filing this, you're trying to show the judge there's no real fact in dispute and I'm entitled to win under the law. And there's no doubt about this. And then the other side's going to say, well, there is an issue of fact, some controversy, and the other side's not entitled to judgment as a matter of law. So I'll say this, Tony, in my experience, it's pretty rare in a collection lawsuit for a judge to enter summary judgment against the collector, in part because sometimes that takes longer than the actual trial itself. Now, some of these trials can take, a day or so, but most take like 20 minutes. So sometimes we give a judge big old stack of stuff and the other side, big old stack of stuff. And the judge is like, well, I can read 200 pages from each side, or we could do a trial in 20 minutes, And so how about we just do the trial and, spare me having to read all this. So it's not a tool that I use in debt collection lawsuits, but it certainly is a valid tool. And let's see here. Here's a little bit more. Had the hearing, judge put in an order saying it will continue. Judge never signed the order. Yeah, what you may want to do is if the judge has like a law clerk or a judicial assistant, a secretary, different states call them different things. Maybe reach out and just say, hey, I was checking to see, has the judge entered a ruling yet? If they say no, sometimes that will sort of prompt them to then go into the judge and say, judge, it's been 6 weeks. We haven't ruled on that motion that Tony filed. And maybe you get a ruling. I would just, of course, be very nice to the court personnel. You don't want them saying, oh, some jerk called us and, he wants you to rule on his order. You don't want the judge having bad feelings about you when they're ruling on you. So, but that's the situation with that. And you have anything to add to that?
Well, it's just interesting you mentioned like the delay in the ruling. I mean, so like technically speaking, a judge cannot rule for, I guess, forever, like in theory. Is that, I mean, there's no timeline to require the judge to rule. Is that correct?
Yeah, I mean, as a practical matter, there are exceptions, but I mean, I've had in federal court one time I had probably 3 years waited on a motion. And it sort of like both sides were writing to the judge, so the judge wouldn't be mad at either side. Like we would write jointly, like, we don't care what you do, rule against me, rule for me, just rule. And so yeah, I mean, it's kind of up to the judge how long they want to wait, but most judges like to move things. So um, here is this, I think we started off with that Synchrony Bank and Rouse Sturm. have that violation. So 1692E8 is under the FDCPA when a debt collector knows or should know a debt is disputed, they have to mark that as disputed. That's the example given. Let me actually pull up that law and we'll just take a look at that. So we've got 1692E. And so this is the beginning part here. Let me get my phone to be quiet here. Debt collector may not use any false, deceptive, or misleading representation. And then an example of that is this 8 right here. So communicating or threatening to communicate to any person, that would include a debt collector, credit information which is known or should be known to be false. So if the debt collector knows that you don't owe $2,000, maybe you owe $1,500, or if they should know that, that violates the law. But that gives us this great example, including the failure to communicate that a disputed debt is disputed. So if you are sued by a debt collector and you file an answer saying, I deny this, that's a dispute in my view. And then if that debt collector updates without marking it as disputed, they would violate this law. Now, what I remember from our person's situation here was Synchrony Bank that sued. So if it's Synchrony Bank and you've disputed Synchrony Bank, unless you have a state law that would mirror this FDCPA, you wouldn't have a claim under the FDCPA. Some state laws will apply kind of the state version to original creditors, so you may have some help there. But just make sure that you can tie in the 1692E8 to the actual company that sued you there. Any closing thoughts here, Stephen? And we're actually going to end on time. It'll be the first time ever. And
all I can say is my neck is still sore from that car wreck that you had with me, and you're going to have.
I had the green light. I had the green.
No. I had the green light. I guess we can't have a summary judgment because there's a genuine controversy at issue here, huh? So
yeah. Judge would say, even though, Stephen, I mean, your credibility is very suspect. I mean, still, they would have to let a jury decide. Between me and you.
Look at that. When you don't have the facts on your side, you go ahead and just destroy somebody's character. That shows something about you right there. Okay, that's right. You didn't say that I didn't do it. You just said that I've got suspect.
So let me tell you this story. There's an old saying that says, if the law's on your side, you pound on the law. If the facts are on your side, you pound on the facts. If neither are on your side, you pound on the lectern. And so I went to trial with this guy. He said, hey, will you help me try this case? And so I said, sure. And so there was never a witness that he would examine that at some point he would not slam his hand down on the podium, make this big crashing sound. And it was sort of done at inappropriate times. And the jury started looking at him and I was wondering what he was doing. And so I asked him during a break, I'm like, why do you always slam the podium at random times? He's like, oh, I think the jury's loving it. I'm like, they ain't loving it, man. So, but anyway, yeah, maybe a little character assassination, but let me just leave you with this thought, Stephen. You are that guy, right? I mean, you admit you are that guy.
I am that guy. There we go. I'm that guy. If you guys want to learn more, go to creditrepairtrainingcourse.com. That's right.
All right, guys. Y'all have a great evening. We'll talk to you soon.
All right. Bye-bye.